Welcome back to the Kelso Report's California Supreme Court review for the 2010 and 11 term. Part 2 deals with cases involving labor law, attorney's fees, and professional responsibility. Well, we begin with labor law. Grocery workers in Los Angeles scored a big win in California Grocers Association versus City of Los Angeles, where the California Supreme Court upheld by a 6-1 vote a Los Angeles ordinance that vests current employees of certain grocery stores with certain individual protections during the 90-day period following a change of ownership of the grocery store. In particular, for grocery stores that are 15,000 square feet or larger that undergo a change of ownership, the ordinance requires first the incumbent owner to prepare a list of non-managerial employees with at least 6 months' employment, and the successor employer must hire from that list during the 90-day transition period. Second, during the same period, hired employees may be discharged only for cause. Third, at the conclusion of the transition period, the successor employer must prepare a written evaluation of each employee's performance. And if an employee's performance is satisfactory, the employer must consider offering continued employment. And fourth, if the workforce is unionized, well, the union and the employer may agree on terms that supersede the ordinance. The California Grocers Association filed a complaint against the city seeking to enjoin enforcement on the grounds that the ordinance was preempted by provisions in the Health and Safety Code, the Labor Code, and federal labor law, and that it violated equal protection. Reversing the Superior Court and the Court of Appeal, the California Supreme Court held that the ordinance was not preempted and it did not violate equal protection. The relevant Health and Safety Code provisions dealt with the topic of health and food sanitation for retail food facilities. Notably absent were any statutes dealing with employee hiring, discipline, or termination. And the city ordinance did not have any substantive food safety standards at all. In short, as the court concluded, the ordinance regulates employment, not food safety, while the statutes regulate food safety, not employment. In these circumstances, there is no conflict between the statutes and the ordinance, and the field occupied by the statutes does not encompass the subject matter targeted by the ordinance. Although the labor law analysis is a bit more complicated, the key question under the United States Supreme Court's decision in Machinist versus Wisconsin Employees Relation Commission is whether enforcement of the local ordinance would frustrate effective implementation of the National Labor Relations Act's processes. California Supreme Court's answer was a clear no. As the court noted, federal labor law is focused on processes of labor relations and negotiations, not upon the substance. For that reason, federal labor law does not generally preempt state efforts to regulate the substance of employer-employee relationships. The Los Angeles ordinance did not purport to regulate the process of negotiation. Instead, it simply provided certain employee transition rights for 90 days after a change in ownership. Accordingly, the ordinance was not preempted by the labor laws. Finally, the California Supreme Court easily rejected the equal protection challenge. Since the ordinance did not affect a fundamental right or discriminate against a suspect class, it was reviewed under the lowest level of judicial scrutiny, the so-called rational basis test, and the ordinance easily passed muster under that low constitutional standard. Our next labor law case involves overtime provisions under California law. In Sullivan v. Oracle Corporation, the California Supreme Court answered several questions which were certified to it by the Ninth Circuit, dealing with the applicability of California law to non-resident employees who work both in California and in other states for a California-based employer. The case involved several employees who worked for Oracle as customer trainers. 2 of them lived in Colorado and the other lived in Arizona. All were required to travel as part of their jobs, and each worked in California during the period relevant to the litigation. They claimed that Oracle owed them overtime pay consistent with California law for the period of time they worked in California, both under the Labor Code and under the Unfair Competition Law, and they also claimed that California's unfair competition law could be used as a basis for recovering damages based on violations of the Federal Fair Labor Standards Act for overtime worked in other states. The The court answered the questions as both a matter of statutory construction and as a matter of conflict of laws principles. The statutory construction piece was straightforward. Section 510 of the Labor Code has no language at all suggesting that the employee's place of residence has anything to do with its applicability. The overtime statute simply provides that any work in excess of 8 hours in one workday and 50 hours in any one work week shall be compensated at the rate of no less than 1.5 times the regular rate of pay. On the conflict issue, Oracle contended that the laws of Colorado and Arizona applied. Generally, California resolves conflict of law issues using the governmental interest analysis. Applying that analysis, the court concluded that neither Colorado nor Arizona had any interest in applying their overtime statutes to work performed in California, while California had a strong interest in regulating payment for work performed in California. So the court answered the first question by holding that the California Labor Code does apply to overtime worked in California for a California-based employer by out-of-state plaintiffs. The second question had to do with the availability of the unfair competition law, that is, Section 17200 of the Business and Professions Code, to redress a violation of the overtime law. The California Supreme Court had previously held that the unfair competition law applied to this type of claim, and none of the parties disputed that interpretation. So that question was also easy to answer. The third question was whether the unfair competition law applied extraterritorially to support a remedy for a violation of the FLSA for overtime work performed by non-residents in other states. The plaintiff sought to use the unfair competition law for these purposes because the FLSA had a 2-year limitations period, compared to the 4-year limitation period applicable under the unfair competition law. Plaintiffs wanted a couple of extra years of overtime pay. The court held that the unfair competition law does not apply extraterritorially in the circumstances of the case, since nothing in the UCL statutes or its history remotely suggested that type of extraterritorial application. So the bottom line for this case is pretty simple. Employees who work in California are generally entitled to the protection of California's overtime laws, irrespective of the employee's place of residence. As for work performed elsewhere, look to the laws of those other states. Well, our next case involves an attorney's fees dispute. Now, like many other states, but unlike the federal government, California has a private attorney general fee statute, section 1021.5 of the Code of Civil Procedure, which authorizes an award of attorney's fees to a prevailing private party in actions involving important public rights or interests. California courts have long construed section 1021.5 to mean that a litigant who has a financial interest in the litigation may be disqualified from obtaining attorney's fees when expected or realized financial gains from the litigation offset litigation costs. This interpretation is grounded in statutory language that requires the, quote, financial burden of private enforcement be such as to make the award appropriate, close quote. If the burden is offset by financial gain in the litigation, well, the award may be inappropriate. The decision this year in re conservatorship of Whitley involved an issue of whether a litigant's non-pecuniary personal interest, in this case such as vindicating the best interests of a child or sibling, can also render that litigant ineligible for attorney's fees. A number of intermediate appellate courts had so held, reasoning that a litigant's non-pecuniary personal interests may be sufficiently strong so that there is no need to create an incentive for private enforcement by an award of attorney's fees under section 1021.5. The issue arose in the context of a sibling's challenge to a decision by a regional center to move a developmentally disabled adult from one center, where he had lived for over 40 years, to a smaller community-based facility. The disabled adult's sister challenged that decision, and in the course of that challenge, established an important precedent, guaranteeing to others access to the statutorily authorized administrative fair hearing provisions under the Lanterman Developmental Disability Services Act. The disabled adult's sibling sought attorney's fees in the amount of $178,000 under section 1021.5. The Court of Appeal affirmed the trial court's rejection of that request, on the ground that the movement had such a strong personal interest in the case, albeit non-pecuniary, that a fee award under Section 1021.5 would be inappropriate. The Supreme Court unanimously reversed. According to the court, both the plain meaning and the legislative history of Section 1021.5 supported the conclusion that the statutory language's focus on financial burden meant exactly what it said and no more. There is nothing in the language of the Act or the legislative history that suggests the litigant's personal motivation should be given any consideration in deciding whether to make an award of fees under Section 1021.5. The court remanded the case to the Court of Appeal to consider whether the litigant had indeed conferred a public benefit. And our last case in this part involves professional responsibility. When a lawyer represents a developer for several years, attempting to assist in securing city council approval for a project, learning confidential information in the course of the representation, can that lawyer, 2 years after his representation has ceased, publicly oppose the project before the city council and solicit signatures for a ballot measure opposed to the project? Well, you would have thought the answer to that question was pretty obvious. But powerful, successful lawyers sometimes have a way of rationalizing almost anything. Fortunately, the answer to the Supreme Court of California was crystal clear. In Oasis West Realty versus Goldman, the client sued its former attorney for breach of fiduciary duty, professional negligence, and breach of contract. The former attorney interposed an anti-SLAPP motion, which is what was before the Supreme Court. Justice Baxter wrote for a unanimous court that the plaintiff easily satisfied its burden of establishing a probability of succeeding on its claims, and the anti-SLAPP motion should have been denied. The court relied upon its leading decision from 1932 in Wachumna Water Company versus Bailey, where the court explained that an attorney is forbidden to do either of two things after severing the relationship with a former client. The attorney may not do anything which will injuriously affect the former client in any matter in which the attorney formally represented the client, nor may the attorney at any time use against the former client knowledge or information acquired by virtue of the previous relationship. Now, the Court of Appeal and the defendant tried to limit this language to situations involving either concurrent or successive representation, or to the actual disclosure of confidential information. But the Supreme Court was not having any of those limitations. From its perspective, the use by the attorney of confidential information against the client's interests, even absent of disclosure, was unacceptable. The Supreme Court reversed the Court of Appeal and sent the case back for further proceedings. When you take on a client's interests, you take them on for life. That's what it means to be a professional. Well, that's it for our Part 2 review of the California Supreme Court's 2010-2011 jurisdiction. We look forward to seeing you back on Part 3. For now, have a great day in the law.